Kimball Jones at Bighorn Law, and actually didn't settle it. He took it to trial. And I got to tell you, like, this dude's smart. What happened was it was an accident that led to death. So somebody died. And the insurance company was USAA. And USAA paid the policy as to the policyholder, which was, I think it was grandma. But grandma wasn't driving. It was grandson who was driving. And so all the releases, everything were signed as to grandma. They paid the money as to grandma. They forgot to include grandson in the release. So what that means is that they were allowed to sue grandson. Now, USAA had a duty to defend grandson in the lawsuit, and they didn't want to settle with Bighorn. Totally fine. However, when you don't settle, when you go to litigation, you do something that's called open the policy. And so we have situations where, say, the standard policy or the lowest policy in the state of Nevada, we call it a 2550. And what that means is for every accident, an individual can get $25,000. If there are multiple people, the person's on the hook for a total of $50,000. Okay? When you refuse to give that money, when somebody says, give me your policy limits, and then they say no, the USAA says no, in that situation, their policy becomes open if you run through a couple of legal hoops and follow, use the right language and things of that nature. There is, a little bit to making the sausage I'm not going to get into here. But when you open that policy, that means whatever you sue the individual for, the insurance company can be on the hook. So Kimball Jones, he took it to trial, and he convinced the jury that there was bad faith on the part of USAA, which opens them up to punitive damages. And the jury found that there were $50 million in actual damages, and then they added $500 million or $500 million in punitive damages.